how to fraud-proof, or 5 reasons, I guess.
Yeah.
What we ended up with is 5 reasons to fraud-proof your H-1B petition.
5 ways. I can think of 1,000 good reasons to fraud, good reasons too, but how can you do it? You know,
5 ways.
Yeah,
yes,
5
ways
Yeah.
to fraud-proof your H-1B petition. Good topic. Fraud prevention and fraud review and enforcement is the top priority with this administration.
Yeah.
We know that it's a big deal. They don't want to see fraud. They're tired of it. They are going to go after it. And H-1B is in the crosshair of their focus recently with an executive order for the H-1B visa that talks about how the H-1B visa has been used and abused, with examples, and why they're asking the employer to pay $100,000 fee to use this H-1B program.
And we're going to talk about a bunch of ways to do it, but you know, there's a question: is that, well, first of all, that's all this stuff is employer stuff. You know, that stuff the employer's doing wrong. And I would just emphasize that when things go sideways on H-1Bs, they tend to punish the employee. And, you know, there's that.
Well, the employer pays a fee.
Sure.
I mean, obviously, there's possible criminal violations.
Yeah, sure.
Right? But it's a monetary thing for the most part.
Yep.
It's a bank account.
Yep.
The bank account had X dollars, now has X minus Y dollars. The employer is going to go to his house at the end of the day. He's going to sleep in the same bed, and he's going to wake up
that U.S. citizen,
having that cup of coffee in the morning and goes back to work with X minus Y in his or her bank account.
Yep.
You, as an H-1B employee, has an entire livelihood disrupted if there's an H-1B problem.
Yeah.
And the recovery can be very costly. That costs you years and years of your time, your investment in the U.S.
Yeah,
unfairly.
Hitting the nail on the head. Fraud is a fraud allegation against you, or is a fraud, more specifically a finding, is essentially an immigration, death sentence. It makes immigration practically impossible for you in the future.
So what is the first thing you should do as an H-1B holder to make sure that you are not getting into this zone of fraud, either caused by oversight, negligence, or appearance of fraud, or anything around fraud? What is the first thing that the H-1B employee should be doing?
I don't like how I say it, Sam. I can put it on the screen. Bam. Nice. Get a copy of your LCA.
Yes. All right. So what is the LCA?
LCA stands for Labor Condition Application, and that is sort of the heart of an H-1B. It's a series of promises by the H-1B employer saying, here's what the terms of employment are. Who is, not even who the person is what job they're going to be working in, what SOC job code, what job classification, for how long, where they're going to work, geographically speaking, and how much they're going to get paid.
And this is a document that the employer files with the U.S. Department of Labor to certify or lay out the conditions. That's why it's called Labor Condition Application. Lay out the conditions upon which they intend to hire a foreign national. It has, like you said, it has a certification at the bottom.
Yep.
So you go to the second page of the document, and it says certified, and it should be signed by the employer.
Yep.
If it's not signed by the employer, it's ineffective. So you need to make sure it's signed by the employer, dated by the employer. It does not have your name on it.
Yep.
But the employer will have to tell you this is for you. So there's be a communication by email or by letter.
So when we say get a copy of the LCA, I guess maybe you're already behind the 8 ball if you have if you don't have one, because your employer is supposed to give it to you as part of the H-1B rules. Yeah. So what's so important about that LCA? Because
you have to look at it, and you have to look at the salary listed, and you have to say, that's the salary I have. I'm being paid. You have to look at the job title, and it has to mention your job title. Yeah. You have to also look at the work location.
Yep.
And it has to have your work location.
Yeah. So I guess the point is that the LCA is going to, the heart of the H-1B, it's going to contain all the details of your employment. And if your employment in reality doesn't align with that, you're subject to scrutiny, be it from the USCIS site officer that comes out to do a visit, from USCIS when they review your next H-1B, from the consulate when you go for visa stamping, or from the Department of Labor when they visit your employer and ask about, hey, what's this person doing?
If the information is not matching, work location is not matching, salary is not matching, significantly not matching, $10 off, it's not a big deal. Yeah. And if the title you're doing is different than the title listed, what do you do?
It's worthwhile.
Antenna. Red. I mean, red. I mean, you have to go. This is danger.
Yeah.
There's a representation made to the government that does not match what I do, what I get paid, where I work.
Yeah.
And that is something that you have to bring to the employer.
Well, yes, and if by chance you find a problem or an upcoming problem, something that's going to change about your work that you need to notify the government about, it makes an excellent segue to our next topic of making sure an H-1B amendment is filed, there you go, when necessary.
Excellent. So that's the second thing to we want you to look at to fraud-proof your H-1B application is to request an H-1B amendment if there is a material change to your H-1B petition.
Yeah, and
H-1B situation.
Yeah, so what the H-1B rules say is, if you read them carefully, anytime there is a change in your work that is material means major, important, maybe the kind that might make the government think differently about your case, you're supposed to notify them. The only thing that's absolutely 100% positive, spelled out in lights from the government that certainly requires an H-1B amendment is a change in worksite location outside of the MSA. So for example, here in Columbus, Ohio, it's Franklin County in the middle, a bunch of counties around it, that's our MSA. If you're supposed to be working in this MSA and your employer moves you, I don't know, Cincinnati, that's a scenario where you might, have to file an H-1B. You will have to file an H-1B petition. But what is the material change, Sam? I mean, I explained it, in lawyer talk, but how do you know whether you have a material change?
Well, and that's the unfairness about the process.
Yeah.
Because we lawyers can talk about it all day long, and we can tell what's material, what's not material. How can you be expected to know? So you listen to us, and we share some information with you. So a material change, if it's a significant change in your salary, how much? I would say less than 5%, it is not a significant change. No. More than 10% probably is a significant change.
Yeah.
Between 5 to 10%, I think different lawyers are going to say different things.
Yeah.
So that's where it's at with the salary. Work location,
yeah, of course.
Definitely.
Yeah.
Adding a second work location outside the MSA. So let's assume
that's a fun one, yeah.
You're traveling and you're spending 1 week. And there's complex rules on that, and we're not going to get into it.
Oh, yeah.
But if you're spending 1 week in Arizona every month, I would say you need an amendment.
Yeah.
So if you're moving a lot, ask the question: do I need an H-1B amendment? Because it's a big deal.
A common question: How about if there's a change in you're an IT consultant, there's a change in the end client that you're serving. And my answer to that question is, there's nothing out there that says inherently that a change in client requires an H-1B amendment. I've had IT professionals being, immigrants and non-ones like friends of mine that do consulting work, and they can honestly say, no, if you change my client, if I'm still doing the same thing, I don't consider that a major important change in my job. But again, the government's never exactly commented on this, and I wouldn't, shout down my client, my employer, if they wanted to file an H-1B amendment for a change of the client that their employee is providing services to. And it's reasonable to think, it is at the very least reasonable to have the conversation when that change occurs. Is there something here that makes this job fundamentally different than what we told the government about last time?
3, Brian.
Yes, sir. Let me go back to the things here. Here it is.
Prepare for your site visitation.
Yep.
Site visitation, if they happen, responding to them is mandatory.
Yep.
They're not mandatory to do a site visitation for every case. Yep. People get confused with that. But if you get a site visitation, you must comply and address. And you have to know what is the most common 10 questions in a site visitation. And it's going to be salary, job title, work, everything on the LCA.
Yeah, what people maybe don't understand about a lot of USCIS interactions, their job mostly is to verify the truth of information they already have. I mean, that's what a USCIS interview for a green card's about, and that's kind of what, they're there to verify facts. So they're typically there based upon an approved case, and the government approved that case because, well, those facts that are set out in that case merited approval. And this officer is just often here to do a quality check, make sure that the reasons that they prove the case are aligning with reality. So, know what that reality is that's put on paper, and you should be able to convey that to that officer.
Who's your supervisor? How are you being supervised? Those are difficult questions. You have to think about how to answer them. How you're being supervised. Are you supervising anyone? What's your job description? What technology you're using? How much you're being paid? How often you're being paid? What's your work location? Those are the normal questions that you'll be asked when there's a site visitation. All right, perfect. Number 4.
Yes, sir. Compare end client requirements to your LCA. But honestly, this applies to I'm thinking about the IT consulting scenario, but I'm really talking about, any H-1B scenario. Part of the H-1B LCA, look at your LCA, item number 1, right, is they will attach a wage level to your work. Level 1, generally described as entry level, requires supervision. Level 2, sort of competent. Level 3, getting some getting up there in authority. Level 4, senior level supervising, that sort of stuff. But those wage levels are sort of attached to experience requirements if you read government policy carefully and in a very sort of obtuse way. Well, who's going to do that? USCIS does. And a very common source of notice of intent to denies or revokes on H-1Bs is they'll talk to somebody at the business and say, hey, what are the requirements for John Doe's position that he's working here? And when somebody thinks they're being helpful to say, John Doe's the best, I don't think anybody can do that with less than 15 years of experience. Suddenly that can put the appropriate wage for a case up to level 4, where it becomes a problem if your employer is paying you a level 2 or level 3 wage.
Or has on the LCA level 2.
Yeah.
So if the employer has on the LCA level 2, the end client or your boss thinks that this job requires 10 years of experience, these do not match, and therefore there is a fraud alert.
Yeah.
The employer is downplaying your job responsibilities to pay you less, but have you do work that is more advanced than what he's paying you. And that's one of the biggest things they look into.
It's a very popular RFE or NOID right now.
It's an easy thing to go and ask the end client, give us the parameters for the job this person is filling.
Yeah.
And if they must have 10 years of experience and you're level 2, you got a problem.
Yeah.
So that is it. Number 5. Brian.
Number 5, a favorite one of our colleague Joe Morhart. He's always happy to look at pay stubs and opine about the accuracy of them. So your pay stubs have a lot of information about H-1B compliance. About what you're getting paid. Oftentimes they have where you're physically located at, your home address on there. And that is another common source for USCIS inquiries about, H-1B compliance. I have seen people I just get consults about these all the time, Sam. It's somebody comes to me and says, Brian, I have an H-1B, RFE or NOIR or NOIDs, and it's because they've seen my pay stubs and they say I'm supposed to be, in Arizona when it turns out I'm in California. And that's really kind of it. I mean, if you're in actual compliance, that's great. But I mean, those pay stubs, if the paperwork says one thing and reality is another thing, that can be a big problem for you.
Yeah, absolutely.
Yeah.
So read your paycheck stub. The other thing about reading your paycheck stub is how frequently you're getting paid, and do the math. So for example, if you're getting paid every 6 weeks, that is a violation of the H-1B rules. You must be paid at least once a month. Yeah. It's in the regulations. Yeah. Or more often than once a month, but not less frequent. And if you're not getting money frequent enough, which is once a month per, on your paycheck, that is a violation, and that's something that they're not going to appreciate, and your status could be in jeopardy. Another thing, Brian, is benching. When there's gaps in pay, the employer comes to you and says, I don't have money to run payroll. I'm going to give you double next time. That's a disaster. Yeah. Because you have a benching, and you also have a
violation of those fundamental get paid once a month rules too.
And also potentially changing the prevailing wage.
Yeah.
There's complex rules on that.
Yeah.
So that really creates a problem for you. And if that happens, honestly, you need to run. You need to find another job. You need to find a way to transfer, and there are ways to fix that. But don't accept that as the operating procedure that is acceptable because you are in H-1B violation and the employer has violated his promises on the LCA to pay you the amount.
Related note, think about, related note, think about, getting paid a salary versus getting paid hourly. Your H-1B LCA is going to say that. But even if you're getting paid a salary, when I look at H-1B pay stubs, I expect those every month to be about equal. Because general rules is, you're supposed to be, how do you calculate somebody's H-1B salary? You take their, if you're paying them monthly, you take what their yearly salary is, divide it by 12, that's their rate of pay. And if those things are varying all over the place, if somebody's paying you hourly, telling the government and telling the world that they're paying you a salary, that can be a problem as well.
Do you have a bonus one for us?
Sam, you say that you say that as almost as if you know that we have a bonus one.
Oh, surprise! We have a bonus. What does it say?
No, the past does not always stay in the past. Just because USCIS didn't bring up something, the last time you extended your H-1B, or just in the past in general, that it couldn't possibly ever come up again. A very popular version of that right now is we're seeing these RFEs. This is not really related to fraud, but talk about the past. It's, oh, we see you have a criminal charge from 10 years ago. And turns out we're bringing that up right now in the context of your H-1B extension, 10 years on. We talk about these things to green card interviews, where they'll bring up like, ooh, when you were on H-1B, 10 years ago, XYZ, question marks like that, Yeah,
absolutely.
Yeah.
Thanks, Brian. This is an excellent bonus point. Very nice. All right, so let's go ahead and take questions. Feel free to drop questions on the channel. We also have a website called immigrationquestions.us, and that immigrationquestions.us is our website, and you can drop questions there if you want them confidential. A lot of people are very uncomfortable now asking questions on their social media handle, and we will pick them up and answer them for you. Then we got a few of them that got dropped through the week, which is another thing that
people
do.
Got some live ones here as well.
All right, so live ones first. Let's hit the live ones. And if you can move it to the screen,
yes, sir.
I can see, Brian.
Yes,
my eyes
that's
are
the dream.
not that good.
They changed the way these things are showing here. Maybe these aren't showing on. Did I press this button? Nope, that's not what I want. Okay, they look good enough. I think they just changed the way they're showing up. Regarding work from home for a consulting firm, do they need to file an amendment when they switch the client? No change in location, no change in salary, but client change from East Coast to Central.
So work from home employers working for a consulting firm, do they, okay, number one, let's flesh out work from home first so we're clear.
Okay.
So what he's trying to say is there has not been a change in work location for this H-1B employee.
He's at home.
And he's staying at home.
Yeah.
But the end client moved from East Coast to West Coast.
Yeah, but well, I don't know what.
While he's working from home.
Well, there's already a way of missing information. Does that mean it's like the same client, but they move their operations, or are they a different client?
I'm going to make it even more difficult. Different client.
Okay.
Okay. Right. We'll answer both ways.
Okay.
Do they need to file an amendment when they switch the clients? That's why it's a different client. Yeah. When they switch the client. No change in location, no change in salary. He's working from home. He's getting paid the same. But the client changed from East Coast to Central. So
essentially, now we're changed, essentially.
So we got two scenarios.
Okay.
Change in location, same client. Change in location, change client. Working from home, same salary, same job description.
Mm-hmm. So, in terms of hours, basically, changing essentially, it sounds like this person maybe is changing their schedule such that I'm getting up an hour later because my client is in Central Time and I'm starting work later. In the context of an H-1B, I've never had USCIS ask about, the time of day you work. It's never come up in the H-1B petition.
Is that a material change?
I don't think so.
I know it's not.
Yeah.
You're not strong. You're not saying, gosh darn it, it's not a material change.
Oh, here. Gosh darn it, it's not a material change.
All right. It is not a material change.
Yeah.
That's not a material change. You're in the same location. I don't care if they flipped your hours, night, day, and nighttime. I don't care. You're working from home. You're sitting in the same chair.
You're a salaried employee.
Flip the same laptop. plugged to the same wall outlet.
Okay.
Okay. You haven't changed, and you're doing the same work.
Sure.
Same client or different client.
Yeah.
If the same work, it is not a material change. An H-1B amendment is not required.
Yeah. Yeah. I really.
I stand behind that.
I'm pretty. I feel pretty good about that. You know, it's.
You don't overthink it.
Yeah.
You're overthinking it.
No, I'm not really overthinking about it. I feel pretty good about that.
This screen is giving me a headache. What is that?
I don't know. No. Now, for the audience, Sam is pointing to the Windows mandated, backdrop on our desktop computer here, and which nobody can see. Sam Shihab.
Right.
I assure everybody, it is fairly distracting. I'll give you that.
It is weird. I get two of them here, left and right. All right, excellent. Thank you. So next question: what must companies do during shutdown if we had to file an amendment? Well, in the last shutdown, of course, you're not asking about the last shutdown. You're asking about the current shutdown. But always, history is helpful.
Analogies are nice, yeah.
History is helpful. The government has given us guidelines, and they basically told us file an amendment and then do the LCA later.
Yeah.
That's what they did a long time ago when they did 4 or 5 years ago. This administration is so busy catching the bad guy, they don't have time to give us instructions. They're too busy doing the right thing for this country that they have not given us time to give us guidelines. What should we do to comply with the law that they want us to comply with? But they have not given us guidelines how to do it.
I was waiting for the second half of that. I mean, we're talking about lawful immigration. How do we maintain compliance?
So there's no instructions. They're not interested in giving us instructions. Sorry, government shut down. You can't get an LCA because the government shut down. Tough luck.
Yeah.
So you are practically in violation, and you have options for you. You have options, and the one that is everybody's leaning towards, and correct me if I'm wrong, Brian, is to wait until the government open up and then file a retroactive application, asking for, which is almost impossible to do because you don't even have an LCA to cover that time.
Yeah, I mean, to be clear, if you were to, my expectation is if you're trying to file an H-1B right now without an LCA, they will immediately issue an RFE that says, hey, no, I've never gotten this RFE myself, because obviously we file with LCAs, but you file with, people have brought me cases where they had no clue what they're doing, they filed an H-1B, they filed without an LCA, and what happens if you file without an LCA, they'll say, you don't give us an LCA, give us an LCA that was certified prior to the filing of this case, or we're going to deny this case. That's what you get.
And you waste your money and the filing fee.
Yeah.
Right now, thank God, it's not $100,000.
Yeah.
But but it's a lot of money, especially if you're an H-1B dependent employer. It's a lot of money.
Yeah.
And you're not going to file a case so you can get an RFE and get a denial.
Yeah.
It just does not
Employers
make
don't
sense.
like burning money like that.
Yeah, I mean it's not. I mean I cannot in good conscience say, well, go file it at least and write an affidavit that says I comply with these H-1B attestations. I'm putting it under oath, but I cannot send it to the Department of Labor because they're shut down. But here's my attestations. Here's my promises, and an affidavit. Please process this case because it's the best I can do.
That's a good idea.
You're gonna get denied.
Yeah.
You're gonna get denied because they don't care.
Yeah.
So the only answer is to file an H-1B amendment when the government.
Well, how do you maintain compliance right now? My answer is
don't.
Well, the most common scenario right now is that amendments are required for changes in worksite. And my answer to that one is find an arrangement with the client to work remotely until you're able to file that amendment, if possible.
But that's the sure way to lose the assignment.
Yeah.
In a competitive world.
Yeah.
And an attorney cannot advise you to break the law. So I cannot tell you, go work.
That's what I wanted to hear.
Go work and deal with it later. It's unethical for me to do that. As a lawyer, I'm not allowed to do that. I cannot tell you, because there's no, if there's a livelihood on the line, I would say go ahead and drive faster than the speed limit. That's okay because you're trying to save life.
Yeah.
But you're not trying to save life. But unless this H-1B, maybe it's saving lives.
Yeah, realistically, it could be a doctor.
Which changes things a bit there. But I can't tell you to move and do it because I can't do it. I'm not allowed to do it. But what else can you do?
Yeah. Yeah, I mean that's it. Like I can't. It breaks your status if you work outside the LCA, and I can't recommend it.
And
It's rough.
if I'm recommending it to the employer, I would say that answer. If I'm recommending it to the employee, I would say the same answer, but I would say, I just want to put you on notice that you're taking a risk with this administration that's really not willing to listen to reason. And that's a risk that you're taking.
Having to do a non-pro-tunc case, a retroactive case, ask for forgiveness after the fact, it's not something I want to be doing right now.
Well, you don't even have an LCA for non-pro-tunc.
Well,
They may not even approve it.
Yeah.
They may not even approve it because you don't have an LCA to say, well, legally they cannot do it.
Well, no, right now, but I'm even talking after the fact. They're talking about.
But you don't have an LCA to cover that retroactive.
Oh, I see what you're saying. So you're talking about the fact that fine, the shutdown. I am fine. I got to start working right this new work site. I'm going to work there. Go to hell rules. And then you go back when the government reopens. You get an LCA. And one of the things on the LCA, if you're not aware, is a
begin date.
Yeah, begin date and end date, and you cannot request an old end date. Ooh, that's fun. That's a very. That's a very good point. Yeah.
And they're not going to approve it, even if the non-pro-tunc is justifiable. But a lot of time, during prior administrations, they would approve something like that. They would say, you know what, we're going to use our common sense.
Yeah.
This administration, my observation is that they are sticking to the rule to the bone.
Yep.
They're sticking to the rule to the bone with zero discretion in your favor in any scenario. We haven't seen any discretion being adjudicated favorably.
Not in the world of employment in H-1B stuff, but I would say, a lot of people come to us in family stuff for denied green cards. If a family case, if a husband and wife screw up their green card, darn it, they're still accepting, discretionary reopening of adjustments of status pretty well. Touch wood. Fingers crossed.
I appreciate your positive spin on it.
Yeah.
But all right, sounds good. So
see what else we got. Go to so this is one where somebody described a fun scenario. And hey, I just filed my H-1B extension. I'm going to sort of fill in the gaps because I couldn't fit all this in here. I just filed an H-1B extension. My H-1B expired on, I think it was 10/3. I filed the H-1B extension just before that. I am subject to the 240-day rule that says I'm allowed to continue working pursuant to my pending H-1B extension. Can I leave the country pursuant to my AOS advanced parole and come back in and consider myself to be authorized to work pursuant to that extending that
240 days.
240 day in the pending H-1B extension?
Yeah. So every H-1B extension carries a 240-day automatic permission to continue to work until until the decision is made, whichever is earlier in time. Yeah. Can I leave the country and come back during that period as the H-1B is cooking, being reviewed, and then continue work, resume working on H-1B 240-day rule?
Yeah.
So makes me nervous. It does not make me comfortable. With this administration.
Yeah.
Because there is no discretion and there's no interpretation outside the rule.
Yeah.
There's no interpretation outside the rule.
Yeah.
You left the country, your 240 days ceased to continue. You came back. You do not. There's nothing in the rule that says upon your return you can resume employment. It doesn't say that. If it doesn't say that, don't assume you can, and therefore you shouldn't. With this administration, because there's no evidence of interpretation that has been positive, that is common sense that we have seen.
Yeah, I guess all I would say to this is, based upon the facts, you have an advanced parole. I'm presuming you have an EAD as well. You probably should, and you are. There's a great fun legal conversation about can you really resume work on an H-1B 240-day rule, but you don't need to. You're going to have that EAD, and I'd rather just keep my answer simple. You could pay us, a sort of thing where I have a consultation with somebody, and I'd say, if you really want me to come up with a great answer to that question, you can pay me a bunch of money, and I will go research it. But there's usually a simpler answer. The answer is you have a pending H1. You have an EAD. Just make your life easier for yourself, and don't obsess about this detail of it.
Yeah. Thank you guys for listening to us. 6:30. We will come back next Monday for another half an hour, and you guys have a fantastic rest of the week. Hopefully the government will open soon and we can all resume a normal life.